Good afternoon, students. In the furtherance of the previous lecture, we are going to study presumptions regarding jurisdiction. We've already studied what is interpretation, how one should pursue towards interpreting a particular law or a particular phrase. Now, coming to one of the most important things. Now we've all interpreted some or the other things while we've studied law, or probably writing even our answers. We try to interpret what exactly does a question seek from our answer, and what exactly, we also keep in mind what exactly is the idea of the person who is going to read our answer is going to perceive from our answer. Now, what are presumptions? Presumptions are basically illusionary facts or probably some considerations which are drawn out of a particular thing. Now, there can be negative presumptions and as well as positive presumptions. There need not be a presumption which might absolutely be right or which might absolutely go wrong. So, there is no right way to presume anything. There you cannot be given a particular part or a set format as to how you are going to presume a particular fact or a particular law or a particular scenario. Now, coming to the presumptions which we are going to deal with today are, now the first and the foremost is ousting, presumption regarding jurisdiction against, ousting of established jurisdiction, creation of new legislation and enlargement of existing laws. Now, this presumption has derived from the past and taking in consideration of the past legal procedures and hearings and the procedures which have been handled by the lawyers and the courtrooms in the present scenario. Initially, if we talk about of the ancient times when there was crown and there were benches and lords, what used to happen was the courts or the lawyers and the judges used to take cases just for the sake of earning money. Their prior motive was not in justice, to provide justice to a people. Initially, it was not considered as a very reputed job, a very reputed, there was no foundation to be a true person, or even for that matter, they were not bound to give justice. All they did was pass judgments and take up cases for the sake of money, so that they can charge high-end fees and consulting fees from the clients which were approaching them. Now, how this has affected, how do we presume is, in taking under consideration the scenario right now, our law has been molded and changed in certain way whereby the cause of inconvenience should be the minimum amount, and the delivery of justice has to be for the maximum people available. This is how we have been presuming and making presumptions as to how law should be taken forward in this society, because this marks and this gives you a sense of acceptance as to at what level is the law being accepted in the society by the people. Now, coming to the second presumption, which is against violation of international laws. We've all studied international law. There are conventions which we've been dealing with: Hague Conventions, Geneva Conventions, Tokyo Trials, Tokyo Convention, Rio de Janeiro Conventions, and so on and so forth. These have played a very important role in determining and maintaining a very well nexus and a connection between the foreign policies of India and maintaining a decorum of Indian services which have been applied outside, which people have been representing India on the outside of our country. Now, what is international law? Any laws which are across borders, any law which have been which basically determine the relationship of one country to another, any law which determines the relationship between two heads of the countries, right? So, what exactly is violation? Violation means any particular law, law which is inconsistent with the conventions and international statutes which we've been following. Now, one of the very basic examples of this particular violation of international law is, for example, there is person A who is an ambassador who has visited India. Now, the question comes is, under what law will this person be protected once he is visiting in India and supposedly commits a particular, a particular crime or a mistake out of no intentions whatsoever. So now what happens is, any law what the courts should try and do is, they should try on the face of it, they should try and construe the rules and regulations as to suppose they should try and construe the provisions of the law whichever they are trying to apply in such a manner that any law which is applied to this particular person A shall not be in any way possible be violative of the international law, because until and unless they are not violating the international law, this person is protective, and it is our moral duty to protect this person since he is representing a particular fellow country of ours. Similarly, if an ambassador, if a particular person representing India outside of India is supposedly charged by any crime, they might end up reading both sides of the law. Even if he is governed by the laws of those sides, they will try and maintain a territorial nexus between the laws so that none of the laws are violated and no international peace and harmony is disturbed by that. There are more what we say, international law does not only international law does not only confine or restricts its horizon or the area of scope towards the only land in international law based on lands or people for that matter. International law also includes sea laws, which is a very you might study in your further classes that international law is divided under two heads, public and private international law, which is a very different topic altogether. Now, international law will also include sea laws. For example, you might have heard about pirates and piracy. Now, there are ships which go about missing. There are yes, pirates do exist. It's not a myth. It's not nothing like that. Yes, pirates do exist. So all these laws which govern that how law of sea is to be maintained, how many nautical miles are legal, how is the fellow person or how is the country where the ship is supposed to go or sail is liable as to how is it responsible to take care of the salesmen and the sailors on the board. Now, coming to the third is extraterritorial operation of a statute. Now, what basically this means, it is a basic presumption that any law, for example, you are considering laws of Rajasthan, you are considering two laws, like for example, we have particular rent laws, like Rajasthan rent laws. Now, there should always be a nexus between two laws, so that it is easy for the interpreter, it is easy for the lawyer and the judge to come to a conclusion which is vast. Now, extraterritorial operation also means any particular law which can expand its jurisdiction to a particular manner, to a particular place. So, it should be in nexus, it should be in particular, what we say, it should be in a particular harmonious way, it should be construed in such a harmonious way that it does not seem that it is only a basic mere illusion which is to be formed. It should actually be applicable. No person who is dealing in law is bound to to give a particular operation, extraterritorial operation to a particular law. Now, coming to the fourth presumption for today is presumptions against creating new and enlarging existing jurisdiction. Any person who is interpreting or who is supposedly sitting on the other side of the bench is not supposed to modify any kind of a rule, is not supposed to transform any kind of a provision on its own until and unless the language of the provision itself is very unambiguous and clear to provide you with a certain exception to give a particular different nature of a punishment for whatsoever. Now, creating new laws and enlarging existing jurisdiction, creating new laws is a very different field altogether. You cannot end up creating a new law on the basis of how you should think the particular act should be judged. Now, similarly, the one example I can give you of is, for example, a person has been convicted of a crime. Now, if a person goes in front of the court, the judge, for example, we have a judge, Now, the judge is not given the power to give him any kind of interim relief until and unless it is solely and clearly mentioned under the provision under which this person is governed or to be punished. Interim relief means a particular temporary relief, a temporary take out from the punishment which he is supposedly to be getting. Now, for example, if this person is supposed to get imprisonment for 5 years with 5,000 rupees of fine, no, the judge cannot on his own discretion and without any clue can say कि ठीक है भैया आप चले जाओ, आपको ना 3 महीने की बेल दे देता हूँ मैं और फिर आप आगे की सजा बाद में सुना देंगे. No, this cannot be done because this is absolutely altering the particular law. You are not supposed to alter. You are only supposed to interpret it so that it is for the benefit of the person who is victimized by the actions of the authority or by any person whosoever is being accused. Now the fifth presumption which we are going to deal with is, now the first is presumption against what is inconvenient. It is always necessary to consider what is convenient and inconvenient when a person is trying to interpret a particular law, because inconvenience will end up giving wrong conclusions and different perspectives for different people. Similarly, coming to the second one is intending injustice. As I told you on the very starting of the lecture, that providing justice has been the main criteria for the development and evolvement of law so far. All the laws which have been amended and repealed have been repealed and amended on a certain particular criteria to provide good justice to the people who have been demanding for them. Even today, when there are new laws or there are new meetings or new bills which have been discussed, the main motive behind the for such discussions and such enactments is to come to a justice, to come to a fact where justice is provided at a greater extent. So similarly, the intention should be to provide justice for a lot of people and for the public for the good interest of the public. Rather than not considering it for a particular individual, the law should be presumed to be made for the greater society of the good, and it should also be taken care of that as to how, at what level will they be accepted in the society. Which is also one more very important point, because the acceptance, we'll discuss the acceptance of a particular law in the commencement of legislation. Coming to the another presumption is impairing obligations and permitting advantage for one's wrong. Now, impairing obligations, basically imparting any kind of an obligation for a person to do a particular act or perform a particular duty or performing a particular action for that matter, should be presumed only if, as again said, if it is for the good, if it is under good faith, if it is doing any good either for the society. For example, you must have heard that there are certain the idea behind this is there are certain people, like for example, the whole idea behind juvenile prisons and open jails was to keep those people who are not so heinous crime holders, to provide them a last chance to attain the humanity which is left in them. And now in case of, if we take about juvenile, the main reason behind juvenile prisons and juvenile prisoners were they should be, they should know and they should understand as to what exactly is the main, what they should know. They should remain amongst people, they should remain under same aged people, so that they do not get influenced by the people who have already committed higher crimes. So obligating a person, for example, even if you talk about open jails में क्या होता है कि कुछ लोगों को अपनी फैमिली के साथ रहना अलाउड होता है. They are given a particular hour मतलब उनको 7 से 5 का टाइम दिया जाता है और उसमें उन लोगों को they are allowed to work and earn a living for themselves. So this is what this allows them to become a good human. They are allowed to learn a normal life. Obviously they're not normal because once you get the tag, you get the tag, but then they are also they are given a chance to become a better person. They are given a chance to reform themselves. And if you might read it in the theories of criminal theories that reformation is the best technique to understand as to how to go about further in reforming the people and the criminals. Now, permitting acts advantages for one's person. This is also basically one of the presumptions which is made while giving an decision over a criminal case. Now, for example, permitting advantage over one's act is always on the negative side, because this does not promote a good part on the justice's side. This does not promote justice. If you are doing this, it proves one side wrong, and on the particular other side, it gives you a wrong impression. You are not providing justice. You are encouraging injustice by providing that person one particular advantage, even by a slight change. Now, coming to the last topic for today is commencement of legislation. Commencement of legislation. What do you mean by commence? Commence basically means starting point of anything, the initiation of a particular step, or taking a step ahead. You have that particular idea which booms into your mind, and then you start working, you start researching upon that particular thing. Similarly, the similar amount of work and hard work and immense amount of research, you have no idea how much research it goes into, immense amount of research goes into commencement of a legislation. Now, how do you go about writing a research? How do you go about commencing a legislation? For example, if you talk about ourselves, you might come to a point in your law career where you are supposed to write papers, which is something very good. You should always do it. I would encourage it. Now, commencement of legislation. Now, we were coming back to the topic. We were discussing how you go about writing a paper. What should be your first priority criteria? How should you go about it? Even while doing a project, for example, I am supposed to make a project. The very first thing is I am going to decide what my topic is. Then my research part follows through. I have decided my topic. After deciding of my topic, I try and bifurcate as to how my research is supposed to be going, how my research is going to be. Supposedly, I am a person my topic is of such a nature whereby my research will only be depending upon the secondary sources of data. So, now, coming to the topic, referring it to the topic we are discussing today, determining whether the legislation is actually in force or not. Now, this also forms a very important criteria is because you cannot take a topic, you cannot come up with a new legislation until and unless it is being practiced. If it is being practiced for a time immemorial, it becomes a custom. So, it is already in existence. Okay, then we have usage, then we have our grunts which have written authenticity, as they give you a written authenticity as to where and how these particular things were, as to where and how these things have been coming into use amongst the society. You have people who've been following this. You have an area where you have a particular tribe of people who've been following this. So you have people who are examples to us as to on what levels, and then you have a different criteria where you can end up it can become a comparison as to how and how much on what extent and level is this particular thing accepted in the society. Now, determination of legislation as to whether it is in force or not plays a very important role, because until and unless you are very well aware of the fact that this particular thing is under existence or not, you will not be able to come to the further steps, which are adoption, promulgation, publication and enactments. Because if you are clear of the fact that this particular thing is existing, it makes it a lot more easier for you and for the people to accept it. Now, for example, we can take examples. For example, we take example of Abortion Act or Surrogacy Fact, for that matter surrogacy. We had no prominent laws regarding surrogacy in say about like 4 or 5 years back. We had no particular laws, prominent laws whereby a particular act or a particular bill was absolutely associated to this topic. Initially, if you look at the times back ahead, surrogacy was considered an omen. People thought since women did not have, any source of money, they are illiterate. They can, lend their wombs on rent. Basically, rental wombs was the titles women were given who were surrogates. So, but we knew that this is accepted. People are still, there are hundreds and thousands of couples and hundreds and thousands of people who still cannot, who are not blessed with the, who cannot be blessed with children normally, like biological procedures, and they cannot be done by that. So surrogacy has come to an, surrogacy was an alternative option. I won't say that it was the prior or the first option which is considered by the people. Yes, but definitely the last option, because we've developed medical sciences have developed in the past couple of years only. IVF, IUF and everything has come into India for the past couple of 5 years only probably. Surrogacy was taken on board like for I think 10 years back before also, but it has come into light right now, because right now I suppose 2019 was the year whereby surrogacy bill was taken out, and I think we had one bill in 2015 which has been whereby the laws have been changed, and there are certain changes and rules and regulations have been changed regarding what we say surrogacy, as to how and when people can adopt surrogacy mothers and everything. Now, commencement of legislation is a very long process whereby it follows under 3 heads. One is adopting and promulgation. What is adopting? Adopting means taking something from somewhere and researching upon it and coming to a particular conclusion. Adopting is going through a process as to how, when this particular law was, what was its introduction, how was it implicated, what were its effects, after effects, impacts on the society. This constitutes adopting. Promulgation on the other hand, for example, a particular law, supposedly surrogacy law, was adopted. Now, we've read under Indian Constitution, any law or any bill passed by both the houses and both the houses has to be signed by the president. Now, if presidential sign is one of the most important feature, and if a particular law is supposed to come into act or come into enactment. Now, promulgation basically is the procedure where that particular law is sent to be signed by the president, whereby he is supposed to read, reread, suggest his amendments and his clarifications and speak about what he thinks about it. That is promulgation. Now, after promulgation, we've signed, we've done everything. The second part is publication. Now, publicating a particular enactment, how is it important? Yes, it is important because publication gives you authenticity. Publication gives you a visual written proof. Even on the digital diary, digital media, it gives you a proof that this particular thing is going to be enacted, this particular thing is going to come into enactment. Publicating not over any head of internet या कोई भी particular website पर जाके publish कर दिया, नहीं. Government gazettes होते हैं, गवर्नमेंट प्रोसीजर होता है कि आपको किस टाइप से पब्लिश करना है. हर गैजेट का एक ISBN नंबर होता है, हर गैजेट का एक अपना एक पर्टिकुलर वो होता है कि उसके क्या फॉर्मेट होगी, किस तरह उसको पब्लिश करा जाएगा, उसके कोई नॉर्म्स होते हैं. दैट इज टू बी supposedly to be followed, and the particular enactment is published under a particular act. Now, coming to the fourth part is enactment. This basically falls under the part where judiciary and legislature is supposed to consider the facts while making an enactment as to what level and what are the chances and the probabilities of this particular law to be accepted by the society. Because eventually the whole process is supposed is being done for the greater good of the people. And अगर वो law बाहर ही नहीं accept होगा, अगर वो law बाहर ही हम उसके presumptions और हम उसके negatives and pros and cons लेके अगर उसको हम नहीं enact करेंगे तो उसका enact करने का कोई फायदा नहीं रहेगा. There have been certain laws which have come and gone, you know, we might even not remember those examples right now. But yes, enactment comes to a part where, you know, you try and test these laws in a particular area. This might also be done even before publicating this particular law, so that it is easier for the people who are eventually, you know, going to be the straight head, you know, who are going to be, you know, eventually being blamed. Ki, you know, you were the person who has come to this particular law, you had given this idea. So coming to the part where enactment is supposed to be done, it is supposed to be taken care of that the particular enactment is for the greater good of the public. And you know, it should not be for our own benefits. Now this completes our module topics for module 5. Now we are left with 2 more topics, which is repeal and revival of statutes and retrospective effect of statutes, which we are going to cover today. Then we are going to start with the most important and the most tedious job, which is presumptions regarding constitution. Thank you.
At St. Wilfrid College of Law, Sector 10, Meera Marg, Madhyam Marg, Jaipur, Rajasthan.